Tick tock, manna to walk. Your silence breeds complacency. Tick tock, manna to walk.
Hello everybody, this is Eric Jose on Making a Murderer on YouTube. I cover the Stephen Avery and Brendan Dassey cases, but also as time passes I've been covering other cases such as the Staircase or OJ and many wrongful convictions of youth. I go over the documents, the photos, the videos, anything case related. So stay tuned because I have many more videos just like the one you're about to see. Hello everybody, how you doing today? I'm here today looking all official looking for you. Well, that's because I'm presenting something from a actual university law panel. What you're going to be seeing here today is a Texas Tech University law panel. Basically, it's professors and students there at Texas Tech University who basically kind of did a review of Making a Murderer, a very thorough review of Making a Murderer. And what we got here is they had kind of several guest speakers that came up at this panel to talk. And so what we're going to be doing is today you're going to be getting the first speaker. Well, you're going to be getting the introduction to the talk, and then you're going to be getting the first speaker. And she's brilliant. She talks about confessions and the Reed technique and why the Reed technique is unreliable. She goes on to talk about habeas relief and, you know, and not necessarily saying that we want to just have habeas relief running without, with the rains, with no rain, essentially no rains on and just running rampant, but we definitely think we need to expand it from what it currently is, kind of thing. So she's very brilliant. She's saying a lot of things that are very smart and just common sense things about criminal justice reform. And like I said, and you'll be watching this right now. It's going to be a premiere on my channel, and just know that there's going to be a few others because this talk is 2 hours. So this is going to be about the first 30 minutes with the introduction to the talk and then the first speaker. And then the next video will be like the second speaker. And I will name them all, of course. Making a Murderer, Texas Tech University Law Panel Talk, so that they will be easy for you to find on my channel. And I will label them part 1, 2, 3, 4. And I think it's probably going to end up being 5, maybe a 6th part. So anyway, these are very interesting. Like I said, this is very interesting stuff. This lady makes a lot of very excellent points, very interesting points. Some of you may have seen something I uploaded to Facebook yesterday. I uploaded the part with one of the speakers where he was talking about all of the so-called left out evidence. Well, you'll get I think it's in part 2 or 3, you'll get every word that guy said. And I know some of you were really chomping at the bit for more from him. So you will get it. You will get it here. So I'm breaking this up because I know a lot of people kind of have trouble sitting down for 2 hours and watching something. So I'm going to break this up a bit so that it's kind of like 30 and 40-minute segments so that it's easier for everybody to digest, because I'd hate for everybody to trail off after the first speaker or the second speaker and not really hear what the third speaker's, kind of thing. I'd hate for that type of situation to happen. So by breaking it up into segments like this, I'm hoping everybody's going to be able to really absorb it at their leisure instead of trying to force themselves to absorb it all in one go. Right, so that's what I'm doing here today. I'll be back, obviously, to introduce the other parts, and I will be uploading these as premieres because, as you know, you're watching this as a premiere right now, and I will be uploading these as premieres over the next week, maybe even into the following week, because I'll obviously be doing live sessions and stuff. So I'll probably be throwing these videos in on the nights when I'm maybe not really able to go live, so that you guys have something to see and get together and chat and have the community, because that's what's important, right? We all have that community, and I think that's very important. So that's what I'm doing here. I'm trying to keep the content so that there will be something every day for you guys, hopefully. That's what I'm trying to do here. But also, this is just very interesting. Also, I mean, don't let me by saying that, don't let me undermine the importance of this information, because this information is extremely valid. It's very smart stuff, and these are actual professors of law and students of law and people actually studying the law who's, the law is their business, right? So, the state and Ken Kratz and all them, they can't just, discredit these guys as easily as they can discredit somebody like me, Mr. Joe Blow American, right? But I suspect they may have trouble, discrediting me at some point. But as it is right now, I have other people here, people that are learned in the law, to go ahead and say pretty much everything that I feel about Kratz in the state. So without further ado, we'll get to it. Here he is.
All right, let's go ahead and get started. Welcome to the law school on a Friday afternoon. This is incredible. I am so excited to see all of you here, and I'm even more excited for this panel this afternoon. My name is Bree Sherwin. I teach legal practice, and like you, I have just been captivated by the Making a Murderer documentary, and I'm sure that's why you're here too. This panel discussion was really born out of a legal practice assignment. Over the break, I'm sure you all were watching Making a Murderer as we were, and Professor Beck and I started talking over the break, and we were saying, you know what, this would be a pretty cool basis for writing in the spring, trial brief assignments and everything else. And from that, we chose assignments and quickly realized that we could only cover a very small portion of it in legal practice. And so we felt that there would be a great need and interest in this panel. I know my panelists are as excited as I am to discuss it today. But first, I would like to introduce Dean Darby Dickerson. She is here to provide a welcome and an introduction. Thank you for being here.
First, I want to thank Professor Sherwin and Pearl and Beck and Redmond for thinking up this panel and taking the time to put it together. I'm very excited to hear what you have to say. Also, thank you for inviting me to share a few thoughts in the beginning of the session. Some of you may have seen the article from the New York Times on February 3rd that indicated that in this past year, 2015, there were a record number of false convictions overturned. There were 149 last year. The people who were exonerated had spent an average of 14 years in prison. 10 of those were capital convictions. Texas actually led the way in exonerations with 54 of them. And since 1989, when the statistics started, there have been 1,733 convictions. I think that you in the audience, and usually people who come to law school, are interested in justice. And I think that's what this is all about. It's not a defense issue or a prosecution issue. It's making sure that our chosen profession is helping to ensure that justice runs as smoothly as possible. We are very committed to this area of innocence, and I want to share a few pieces of news for you, and hopefully many of you will take advantage of some of the new opportunities that we have. In addition to the assignments that you've done in LP, many of you may know that Professor Tracy Pearl this past year offered an advanced criminal law seminar based on the Adnan Syed case, and I'm pleased to say you're going to be repeating that seminar into the future, so that's something to be aware of. And we'll continue, like we brought Rabia Chaudhry and Jim Trainum in, we're going to continue bringing people involved in these things here to campus. A big piece of news, and a huge thanks to Professor Pat Metz, who's in the audience. Starting in August, we are going to have a live on-site innocence clinic here. So some of you are, We have long been affiliated with the Innocence Project of Texas, but other people outside of the school have really run the externship programs for students. We're bringing it in-house. We're going to be selecting the students this spring to be the inaugural group. And that's also going to bring other opportunities for pro bono work in this area. So those of you trying to get your pro bono hours, if you're interested in this and want to, be involved and have sort of a path to the clinic, please look for the signs and announcements on this. The other thing you may have heard is we have done some sponsorship on the Undisclosed and the Truth and Justice podcast. We actually admitted our first student who applied to us from our advertisement on that program. So applications of people interested in this have been rolling in. And I'm also proud to say, and you may, if you listened to the last episode, you may have heard this, but we have struck a deal with the Truth and Justice podcast, Bob Ruff, for our students to be his legal researchers, to research issues that he's interested in, because he's not a lawyer and he needs some help in that regard. So we're going to have ongoing questions related to cases. You won't be given legal advice. We have worked out the ethics of it. But again, if you're interested, you can work on these, and he's actually committed to having some of our students on the air to talk about their research in this area. So that's going to be really cool. And for those of you here, this may be the biggest news, is I've invited Dean Strang to campus, and I'm in talks with his publicist. I was hoping to hear today. We're trying to work it out for this spring, but either this spring or in the fall, I think we're going to have Dean right here. So that will be a wonderful follow-up to this panel. So that's my good news and updates, and I'm as anxious as you to hear the panel.
Thank you, Dean. Okay, so let's kick off this panel discussion. I wanted to briefly introduce each of our panelists and then give you an idea of how the panel discussion is going to go. First, I'd like to introduce Professor Tracy Pearl. A lot of you recognize her as your criminal law professor. I have section 4 in here, so you probably see a lot of familiar faces. She also teaches environmental law and criminal procedure. She's going to be speaking on criminal justice issues that are brought up by the documentary. Next, I have Professor Brandon Beck. He is a research and writing specialist for the Federal Public Defender's Office here, and he also teaches legal practice, and he's going to be speaking probably a lot about the recent criticisms of the documentary, and giving his perspective on things. Next, I would like to introduce Assistant District Attorney Ricky Redman. She is the Assistant District Attorney for Lamb County. She's a graduate of this law school. She actually started as a prosecutor here for the Lubbock County DA and then moved over to Lamb County. And she was also an adjunct professor teaching trial advocacy here. So she's going to give perspective on the documentary. And last, but certainly not least, the other Professor Sherwin is part of the panel today. Professor Sherwin, as you know, is the Director of Advocacy Programs here, and he also teaches a variety of classes, including trial advocacy and appellate advocacy. And so I think his talk is going to focus on some of the incredible trial advocacy that we've seen in the clips from the Making a Murderer documentary, as well as a couple of issues that were key to the progress of the trial and what happened there. So the way that the panel is essentially going to progress is each panelist is going to be speaking for approximately 15 to 20 minutes. I'd ask that, I know everyone has a lot of questions, I know my class has a lot of questions, but I'd ask that you'd hold your questions until each of our panelists we complete the entire panel discussion. And then after we've completed our presentations, I will open it up to questions, and you can ask as many questions as you want. So without further ado, I'll introduce Professor Tracy Pearl. Thank you.
Thank you so much, and thank you to Professor Sherwin for inviting me to be on this panel and to talk with you about this incredibly compelling and troubling series that's gotten the general public all in a tizzy about criminal justice issues. So when Professor Sherwin invited me to speak, and I was trying to think about what I wanted to say, there was an old Yogi Berra quote that kept coming to mind. And that's that it's just deja vu all over again, right? Because as you see, for as shocking and as disturbing as the documentary was for a lot of people, I would venture to say that it was not surprising at all for people familiar with the criminal justice issues that we are currently facing. Nothing that I saw was particularly surprising. It was all incredibly upsetting, but nothing really shocked me, right? The only difference now is that more people are paying attention to these issues. And so my thesis for today is that the Stephen Avery case, as presented in the series, is really just a microcosm of the current issues that we're facing in the criminal justice system in the United States. And I want to highlight three of those issues for you today. So first, I want to talk about false confessions and the staggering problem that we have with securing them in this country. Now, if you've attended Jim Trainum's talk in the fall, he talked about this issue as well, and very successfully. And I want to highlight some of what he said and some of the issues raised by the documentary itself. Because this is one of those phenomena that people refuse to believe actually exists, but in fact happens all the time with profoundly bad consequences. So how often does this happen? Well, a number of studies at this point show that false confessions, or something very close to them, occur in 25% of all wrongful conviction cases. 25%. False confessions have led to the convictions of thousands upon thousands of people in this country. Now, this is a number that people find completely implausible for one very simple reason. People believe that they would never falsely confess to a crime, and so the likelihood of anybody else doing it is extraordinarily low, right? Why would you confess to a murder that you didn't commit? Only a fool would do that. That's crazy. No sane person would ever falsely confess, correct? Well, wrong. Study after study after study has shown that pretty much everybody is likely to falsely confess under circumstances that are significantly less onerous than you might expect. You think that you wouldn't confess? Well, science says that you're wrong, that in fact you're likely to falsely confess much sooner than you assume that you might. And why is that? And why is it such a problem in the United States? Well, it's because of one particular interrogation technique that virtually every law enforcement agency uses in this country, and that's the Reid technique. Now, the Reid technique has two distinct phases. In the first, the behavioral analysis interview, law enforcement officers are tasked with determining whether a suspect is lying to them. So they'll start with very low-stake questions to get a sense of the baseline demeanor of the suspect, and then they'll move on to more and more probing, more high-stakes questions and see how the suspect reacts. And the Reid technique teaches officers to look for certain behavioral cues that indicate deception during this time. Things like touching your face, fidgeting, moving your feet, looking up, looking down, looking to the side, right? The Reid technique tells officers that all of these are signs that the suspect is lying to them. Now, unfortunately, one of the big problems with the Reid technique, and one that I'm not going to highlight very much here today, is that actually all of that is wrong. Science has shown that all of those behavioral cues actually don't indicate deception at all. And so as a result, police are actually terrible at determining whether or not suspects are lying to them. Repeated studies have shown that police officers are no better at determining whether a suspect is lying than random chance. And a few studies have actually shown that police officers are worse at determining when people are lying than a member of the general public, largely because of this Reid technique training that they receive. Police will swear up and down that they know when somebody's lying, but actually they don't. And the problem is, when they think that a suspect is lying, which is quite often, they move into the far more nefarious phase 2, and that's the interrogation phase. During this phase, the tone of the interrogation shifts radically. The officer is instructed by Reid technique manuals to refuse to hear denials of guilt. The sole goal of the officer at this point, or at least the primary goal, is to secure a confession. And they'll try to do so using various techniques. They're really not interested in gathering information. They're interested in getting a confession. And so they'll do things like minimizing. They'll say, we know you committed the murder. Of course you did. But it was a mistake, right? You didn't mean to kill her. Of course you didn't. You're a good person. We actually see this happen in episode 2 of Making a Murderer when Stephen Avery is interrogated, right? He keeps saying, I didn't do it, I didn't do it, I didn't kill her. And the officer says, don't lie, we know that you did, but we know that it was a mistake. And then he tries another tack. He says, well, we know you were angry. Of course you would be angry after spending all of those years in prison, right? Now, fortunately, Stephen Avery doesn't confess here. This isn't his first rodeo, so to speak. He stands firm. But a lot of people don't. Well, why is that? For two reasons. The first is that under the Reid technique, police are not only permitted, but are actually encouraged to misrepresent to suspects what they know about the case and the evidence that they have. It's called baiting. So imagine this scenario, which is actually a completely plausible one. They have a suspect for murder, right? They don't have any evidence at all, and they're not certain the person is guilty, but they might say something like this. We know that you did it. We just got reports back from the lab, and your DNA is all over the victim, the murder scene, and the weapon. We know that you did it. The DNA conclusively proves that you did. And here's the thing. If we show a jury this DNA evidence, of course they're going to convict you, and they're going to send you away to jail for life. But here's the thing. If you just confess, if you work with us, if you explain what happened, we can help you. We know this was a mistake. Just tell us what happened, and we'll make a recommendation to the prosecutor that you walk away with just a couple of years in jail, 1 or 2. It was an accident. If you don't confess, however, we'll send it to the prosecutor, and we're going to charge you to the full extent of the law. You will be convicted, and you're going to go to jail for life without the possibility of parole. People assume cops wouldn't lie to them about the evidence, right? And so it's really surprising to hear this. And you can imagine a situation in which an innocent person, faced with this statement on the part of law enforcement officers, makes a rational choice. The police are right. If there is indeed DNA evidence, the likelihood that they'll be acquitted is virtually 0. And so it's only rational for them to say, well, I'll confess, I'll get a year or 2, and then I'll be out, and I'll be able to watch my kids grow up. And so that's exactly the calculus that people make, right? In fact, people less likely to commit crime have been shown to be more likely to falsely confess than hardened criminals. Hardened criminals know how this works, right? They know that police will lie to them. They usually know to follow good practice and not talk and ask for a lawyer, right? But innocent people, people who don't commit crimes, right, don't know this. They're under an extreme amount of stress, they're baffled, they're surprised, they're confused, and so they're more likely than we might think, to make false confessions. The second reason that people falsely confess is that they're vulnerable. They're young, they have cognitive impairments, they may be mentally ill. At least 2 of those were true for Brendan Dassey, right? When I watched the recording of his interrogations in episode 3 of Making a Murderer, 2 things were incredibly clear to me. Number 1, this was classic Reid technique, right? This was just straight down the middle of the plate, Reid techniques that are taught to law enforcement agents all over the country. The second thing that was obvious to me was how vulnerable this gentleman was, how easy it was for police to feed him what they wanted him to say and how they wanted him to say it, right? And how he had no understanding of what was happening or the consequences of saying what he was saying, right? He tells his mom later, I was just guessing, just like I do on my homework, right? Studies have shown that vulnerable people like Brendan Dassey not only can falsely confess in large numbers, they're actually likely to falsely confess when subjected to Reid techniques. The problem here, the biggest problem, is that juries are virtually always going to convict when a defendant has confessed. Even if the defendant has very good defense attorneys who do a very good job of explaining why the Reid technique is so problematic and how it can elicit false confessions, and how it did in this particular case, jurors refuse to buy it. Again, it's the delusion people have that they would never falsely confess, so if somebody has confessed, they must be guilty. Teresa Halbech's brother makes a statement during the show, which he says that all the prosecution has to do in order to convict Stephen Avery is show the tapes of the Brendan Dassey confession. And he's exactly right, right? During the Q&A, I'll give you examples, if you're interested, of cases where jurors have convicted people in the face of confessions that defy the law of physics, right? Of confessions even where the DNA shows that the defendant was not present at the scene of the crime, right? People refuse to believe that people falsely confess, and so we have false convictions in this country. So where does this leave us on this issue? Well, most people who study this issue believe that we need to forbid the use of the Reid technique in this country. It's a great technique for getting confessions from guilty people, but it's also a great technique for getting confessions from innocent people, right? And for that reason, a significant number of Western countries outside of the United States have actually banned its use because it leads to so many false convictions. And in its place, they've substituted other techniques that are less coercive and more designed to elicit information and truth than to obtain a confession. That, I would argue, is a reform that we need to make in this country as well. The next big issue that looms large, both in this case and in the criminal justice system right now, is DNA testing and how it's a very, very sharp, double-edged sword. On the one hand, DNA testing is the reason, largely, that we have been able to exonerate so many innocent people over the last few years. It's the reason that Stephen Avery was exonerated in his first case, right? The DNA testing proved that he didn't commit the rape. As of January 15th of this year, there have been 337 post-conviction DNA exonerations in this country, 263 of those since 2000. In virtually every one of those cases, the DNA evidence excluded the defendant from the scene of the crime. It shows that they didn't commit the rape or the crime or the murder because they weren't there, right? The DNA isn't present. It's powerful evidence of innocence that we should be grateful to have. The problem is that DNA is also very powerful evidence of guilt in a very different and very manipulable way. If there's a positive DNA test, what that means is that the suspect's DNA was present at the scene of the crime, or at least that's what everybody believes. And a positive DNA test is almost impossible to overcome in court. Virtually no jury is going to acquit in the presence of a positive DNA test. But as we learn in Making a Murderer, these DNA tests are very, very sensitive. It is extremely easy to contaminate DNA evidence with really anybody's DNA, right? This lab tech right here contaminates the DNA test of the bullet fragment with her own DNA, and she's a certified lab tech, right? And when that contamination occurs, it always works towards including somebody's DNA rather than excluding it. My understanding is that you can't contaminate a DNA sample in a way to exclude or take out somebody's DNA. You can only contaminate it in a way that adds somebody else's in. And when that happens, it will always point to the guilt of the suspect and never towards the innocence. It's always going to be a false positive problem rather than a false negative problem. So how can this contamination occur? Lots of ways. Police handling the various pieces of evidence that they've collected may handle one thing with the suspect's DNA evidence on it, and then easily transfer it to another piece of evidence if they're not meticulous about things like glove changing, right? An officer who has spent time at the suspect's house or with the suspect, him or herself, and then goes back to the office and handles evidence retrieved from a different location may contaminate it. Lab technicians can easily contaminate evidence. If a lab technician handles a baseline sample from a suspect, right, their DNA that we know is their DNA, and then they go on to handle another piece of evidence without very, very closely following laboratory procedures, they can introduce the defendant's DNA onto another piece of evidence. And of course, if the police wanted to contaminate a DNA test or place DNA at a relevant place, it's incredibly easy to do so, despite what the sheriff of Manitowoc County would have you believe. Now, I don't know whether there was purposeful DNA contamination in this case or not. That's really up to you to decide. What I do know, however, is that it's very, very difficult. We don't have a good way yet of telling when a DNA sample was contaminated. And B, juries don't really care. DNA testing has been built up in our society to be the gold standard of evidence, right? The DNA doesn't lie, people say. Except that it does. And when it does lie, it always lies in one particular way. It lies in saying that the defendant's DNA was present on a piece of evidence when really it may not have been. And although the tide is changing a little bit on this, overwhelmingly, when the defendant's DNA, or when the DNA says that the defendant was present, the jury is going to convict. It happened here in this case if you believe that this particular gentleman is innocent. We need to work to promote a better understanding of DNA evidence in this country, its strengths and its shortfalls, the ways that it can go wrong, and the consequences when it does. We also need more consistent, federally mandated laboratory standards for DNA testing. We don't have them right now. We have recommendations and good practices, but there's really very little oversight of these labs, and there needs to be. The last issue I want to talk about today is habeas corpus and how virtually impossible it is in this country to be exonerated once you've been falsely convicted of a crime. Now, as an exceptionally brief primer for the 1Ls here who may not be familiar with habeas corpus is the post-conviction process through which an innocent person who has been wrongfully convicted can obtain legal recourse. In its current manifestation, it is an incredibly Byzantine and lengthy process that virtually always ends with a court ruling against the petitioner. Just filing the right kinds of motions at the right times with the right courts can be incredibly difficult to do and figure out, even for attorneys. And this is the process that Stephen Avery is in now. Any exoneration that he gets, short of a pardon from the governor, has to come through the habeas process in some way. The problem is that it's virtually impossible to obtain habeas relief. A 2007 study by the Department of Justice found that less than 0.4% of all habeas petitions obtain any kind of relief, whether it be the granting of a new trial, a new sentence, or the ability to lodge another appeal. An even smaller number of those cases will actually result in the prisoner being freed. Now, on the one hand, we want to make it fairly difficult for people to get out of prison once they're in it, right? We don't want the habeas process to be too easy. On the other hand, we don't want to make it impossible because sometimes, perhaps even more often than we think, innocent people are going to be convicted, and we want to be able to free them as quickly as we can when they are. The Innocence Project, for instance, estimates that somewhere between 2.3% and 5% of all prisoners in the US are innocent. That's somewhere between 20,000 and 100,000 people who are wrongfully incarcerated at any given time. These people need a reasonable way of exonerating themselves, and the current habeas system is not that way. It makes it virtually impossible for them to do so. Now, habeas reform is thorny and complicated and dry. It's not a sexy issue like DNA testing or false confessions, and it's not even particularly easy to explain to people, but we are in desperate need of it in this country. We need a habeas overhaul, and unfortunately, I don't think we're likely to get one anytime particularly soon. So where do we end up here? Well, clearly there are a lot of systemic issues in the criminal justice system. Take my seminar if you want to explore some of them. And this case just captures a small few of them, and they're upsetting to think about. I do have faith, though. I do want to end on a positive note. I have faith that shows like Making a Murderer and podcasts like Serial and Truth and Justice are bringing long-needed attention to these issues that have been largely overlooked by the general public up until this point. They're making people care, and I think that's an incredibly important first step. And also, I have faith in all of you, all of the future prosecutors, defense attorneys, and judges that are sitting out there right now. By educating yourself about these issues, thinking about them, and caring about them, you're less likely to perpetuate them going forward and more likely to make the kinds of reforms that we need to make the criminal justice system better. Thank you.
Thank you, Professor Pearl.
All right, so as I said, fascinating stuff, and that was just the first speaker. You can expect more of this coming forward here, or moving forward here in the next week or so. Like I said, I'm trying to upload one of these to fill any gap where I can't go live for you guys. I know you guys got lots of questions. A lot of you are like sponges ready to suck up all this information. So I'm going to do my best to try to get as much information I can to you. Quality information, credible information. That's what I want to load you up with. So that's what I'm hoping to do here. And hopefully, like I said, we'll have these little informative videos to kind of fill in the gaps, maybe on the days or nights when I can't go live. So hope you guys enjoyed it. Hope you guys will continue to enjoy these segments. I think they're brilliant. I mean, the information here is just phenomenal and top notch. So if you haven't already, please hit subscribe, and we'll see you.